Part 7 and the proposed changes to the Immigration and Refugee Protection Act.
Thank you, Minister. Next, Senator Osler.
Thank you, Mr. Chair. Thank you, ministers, for being here today. And my question is for Minister Diab, and it's on Part 7 and the proposed changes to the Immigration and Refugee Protection Act. Clause 72 empowers the Governor and Council to cancel or vary immigration documents, including permanent resident status, if it is in the public interest. Now, my home province of Manitoba, we have permanent residents who fill persistent labor shortages in high-demand sectors like healthcare, technology, and skilled trades. So typically holding PR status confers security of status within Canada, but this change, along with proposed Section 87.302 sub 1, which cancels or varies documents, does make PR status vulnerable to revocation or suspension. And I'm just wondering, what were the reasons that the government decided to apply these new powers to permanent resident status?
We're all talking here and saying the same thing.
Sorry.
No, it's okay. We cannot cancel permanent residence with these clauses, so I'm not sure where you're reading that or what. We'd be happy to look at that, but it's not for permanent residents. This is strictly for those that are here on visa, so temporary, whether it's visitors, but certainly not permanent residents.
Okay, so for clarification, proposed Section 87.302 sub 1 to cancel or vary documents, which does actually say permanent resident status. So if there was a matter of national interest, does it make those permanent residents potentially vulnerable to a change in their status?
So the bill itself is not designed to address people's status. We can't take away people's status. That is a matter of right, and people can obviously challenge that. What it does do is it strengthens the control over the documents, the immigration documents, and the application in the inventory when it's necessary in the public interest. So this isn't new. We actually already have a lot of these powers. The difference is we now have to do them one by one. And I learned that when I came as a minister, what they told me, what they did in COVID, they had to do them one by one, which was very time-consuming, inefficient, whatnot. If we can put the powers that are there, what they did during COVID could just have been done at once by suspending, so that it would have been much better, and as opposed to, I guess, telling the pilots or whoever, as what was explained to me, that we had to put the quarantine provisions so that you can't fly over Canada or something of that sort, is what I was being told, in order to get around not allowing people to come into Canada. So that would help us with that situation. The same as if there's a scam in our security features or in our immigration system where there's a cyber attack or so on. We would then be able to stop all inventory and all intakes coming in all at once until that is figured out.
So thank you, Minister. And so perhaps if the department now or perhaps at some point in writing could provide some clarification. I know the previous section does talk about the application process, but Section 87.302 sub 1 does make it sound like status could be varied or changed. So
we'll take it back.
That would be wonderful. Thank you for my concerned Manitobans.
So, Minister, just in regard
we'll take it back.
If you could send the response to the committee chair, to the clerk, we'll appreciate it very much. Next is Senator Hay.
Thank you, Mr. Chair, and thank you, ministers, for all the work you do for all the people in Canada, not just the Canadians in Canada. I appreciate that. I may be asking a tough question that's likely a worry on people's minds. And as my 88-year-old mom would say, just get it out on the table. So I'm putting it on this table. Minister Diab, stakeholders argue that C-12 could lead to mass deportations without full or fair hearings. And we are seeing what this kind of policy change can do right now in the United States with the federal agents and their treatment of American citizens and acting in a way that's not transparent and against human rights, from basic human rights to the most egregious. So my question is, what safeguards will the Government of Canada ensure that asylum claimants or newly arrived immigrants will receive meaningful procedural fairness through Canadians' immigration system, and that they will have access to judicial review before being potentially removed from Canada?
So thank you. Maybe I will speak here about the pre-removal risk assessment process that is ultimately the one that is in the Act. Of course, prior to people getting on that, they would have probably claimed through other channels as well. They may have claimed, but let me talk about the pre-removal risk assessment, as I alluded to earlier. It's been in Canada for over 20 years, and it has been upheld by numerous judicial reviews as meeting Canada's international obligations. And it was designed in response to our non-refoulement obligations, and not designed explicitly for failed claimants, but rather for individuals who may be removed from Canada who allege that they're facing a risk in the country to which they would be returned. So that process is initiated when a client is no longer eligible to remain in Canada and is subject to an enforceable order. So, an order would have been issued from CBSA that you have to leave, and at that point, that's when if they feel that that there's a sufficient reason that they can say that they're facing a risk of persecution, torture, threats to their life, or cruel, unusual treatment, they are allowed to stay. But that's the threshold they have to face. Even at that point, though, they can still challenge and through the federal court as well.
May just a clarification. Do you see that C-12 could lead to mass deportation in Canada?
So it's not designed for mass deportation at all. There would have to be a public safety issue, as I said. There would have to be a real threat to Canada. Yeah.
If I may be very clear on this, I would categorically reject that notion. This is not in any way meant for mass deportation. We are Canada. The C-12 reflects the values I think we espouse. Our sense of what we see in other parts of the world has driven how we do things differently in Canada, and to make sure that the right lens, the human rights lens, as well as a humanitarian perspective, is embedded in the legislation. So while I think your 88-year-old mother would be probably right in, appropriate in thinking that what's happening in other places can be replicated here, that's not the case with C-12, Senator.
Thank you, ministers.
Thank you.
Thank you, Mr. Chair. So my question is with regards to Part 7 of the bill. So what we're talking about here is to allow the government to cancel, suspend, or change immigration documents, and to suspend, cancel, stop accepting new applications. I guess accepting new applications is something that currently exists. I'm concerned more about the part around cancel, suspend, or change immigration documents. So could you say a little bit more about what would be included in that? Why you need to do that? Do those powers exist currently, either at the departmental or the ministerial level? And then we've added, or the House has added, the requirement that these are consistent with the public interest. So my question is, what is public interest? How do we define that? How loosely you can define it? And what could And could this be open to, if I can just pull out an example out of the air of a leader who doesn't like a certain religious group or certain ethnic group, people from a certain country, and just says, no more of that group?
Thank you. Thank you for the question, and I'm very glad that we're going to be able to tackle this, because I know there were some questions for the minister as well, and lots of interest. It's too bad Senator Osler had to leave. So very specifically, what is in scope are documents, and documents are different than status. And maybe a simple way of thinking about it, because I was kind of in the back ruminating about that, is a visa, as outlined in the 302 subsection 1, is a vehicle for travel. And status is what you have in Canada. So, for instance, what is included in the scope of these documents are temporary resident visas, electronic travel authorizations, temporary resident permits, work permits, study permits, permanent resident visas, PR travel documents, and PR cards. What is not included are things issued under the Citizenship Act or the Passport Order, applications for asylum in Canada, applications for pre-removal risk assessment, applications for extension or restoration of status, and in Canada permanent resident applications that lead directly to permanent resident status. So for things like that, that would be H&C, public policies, in Canada spousal applications. So why this is important is that these authorities do not give the order, the governor and council, because it's not a ministerial authority, it's governor and council, any authority to revoke status and thereby have, what we were having this risk of mass deportations. What it is, it allows you to pause applications, alter or vary documents, and potentially cancel documents, absolutely. But when you cancel a document, so for instance, a work permit, or the person's status in Canada is not at that point affected. What it means is that they can no longer work. So their status is actually conferred when they enter the territory. CBSA allows them to enter, and the revocation status is under sections 47 and 46 of IRPA itself. It's not about status, it's about documents. So examples where we might use this. One example, yes?
You made a difference between documents and status, but isn't it documents that give people the status? What's the difference between the two?
They don't, yeah. So a document is purely that. It allows you to do something. So your status in Canada is conferred only after you travel and you're landed. So from a permanent resident situation, if you're overseas, you're issued a permanent resident visa. You travel to Canada, you're landed by a Canada Border Services Agency officer. That's your status. So you now are a permanent resident of Canada. Your permanent resident visa is the vehicle that allows you to travel to Canada. That is the document that we're talking about that can be impacted or affected. Similarly, a temporary resident visa. So you travel to Canada on a temporary resident visa. Your authorized period of stay normally is 6 months. That's a general kind of situation. If your visa is canceled, your validity, your authorization of status in Canada remains. You're still allowed to be here. What's going to happen is if you leave the country, you no longer have a visa to travel back on, for instance. If you're a worker and your document is canceled, you're still a visitor. And I also want to mention that this is not a punitive measure. So by that I mean, if there's some identification of some kind of fraud or mass, like we've been using an example of a cybersecurity attack. So somebody hacks into our system, issues all of these visas to potentially nefarious travelers or whatever. We find out about it through our regular checks, we get a tip, et cetera, et cetera. We can do a couple of things. We can pause all of those applications and take a look at them and try to identify better what the situation is, or we can go ahead and just cancel them and say, forget about it, we have enough evidence. And when I say we, I don't mean the Minister of IRCC or the Minister of Public Safety. There would have to be a case that is written with an all-of-government approach that goes to the Governor and Council for consideration. All of the pieces of the puzzle would be included. Who exactly are the document holders? What are the documents? then we'd have to convince the governor and council that this is actually acting in the best interests of Canada. And then it would be the governor and council who makes that decision. And so that would be published in the Gazette, and we have a requirement now to report to Parliament within 7 days. What else do I want to say about safeguards there? So in the situation of a minister who kind of had, again, an ill-advised focus on a certain population or anything, it would have to convince all of their counterparts in the government that this is a worthwhile endeavor, and then prove to the governor and council that this is truly in the public interest. So there's checks and balances there.
And have to put it out publicly.
And have to put it out publicly and be subject to those situations.
And the matter of the public interest, how do you
Yes.
define that, and how can that shift over time?
Right. So public interest originally in the bill was purposely vague, and it was just actually defined as the public interest. But there was an amendment that was passed, actually, that now better defines what the public interest can mean. And it says it is the purpose to address matters such as an administrative error. So say we had a system glitch and there was a bunch of documents that were issued with incorrect dates. Fraud, so again, in a proven case of fraud from our partners. Public health, so we had the pandemic example, for instance. We could, and you mentioned, that we can pause applications or stop accepting. We cannot. There is no provisions under IRPA right now to stop accepting applications. That does not exist. So right now, although there's programs that have caps, but temporary residents, like apply, just because we're not accepting you, they still sit in our inventory until we can process them. Public safety or national security. So all of those pieces would have to fit within one of the cases to be made for public interest.
So that could be a group, if it was,
Yes.
if it was deemed that, I didn't want to use slipshod
Right.
language, but if there
Right.
were a couple of terrorist attacks that came from a certain group, from a certain country in the world, we could just say no more of them, of that entire
Well,
country.
I don't know that would, again, I can't presuppose what the government might want to do or what the governor and council would accept, but in a national security situation, I would actually think that type of example would be, is if we had identified that we knew certain actors had applied for visas, and we have evidence that proves that they are part of a terrorist organization, that we could cancel or alter or pause their application or their document. Yeah.
Thank you.
Fairly extensive answer here.
People who forget what they read before they even finish the page. It's not ADHD, it's an untrained brain. Here is the brutal truth.
Thank you. My question has to do with immigration.